Hi, good morning. I'm Jeff Andre, Deputy Assistant Secretary for Policy, Planning, and Innovation in the Office of Post-Secondary Education here at the U.S. Department of Education, and I'm happy to welcome you to this virtual hearing. Since President Trump signed the One Big Beautiful Bill Act into law barely a month ago, Secretary McMahon and the team here at the department have been working hard to quickly deliver the benefits of this once-in-a-generation legislation to the American people. Today's hearing is an important step in that process. Later this month, we will select from your nominations the members of the two negotiating and rulemaking committees that we previously announced. We will work together over the subsequent weeks to share ideas, jointly review draft regulations, and find constructive solutions that will lead to thoughtful, reasonable final regulations implementing the new law in record time. Before we start the hearing this morning, I want to introduce our new Undersecretary at the Department of Education, the Honorable Nicholas Kent. Nicholas Kent was sworn in as the 15th Undersecretary of Education on August 4th, 2025, following his nomination by President Donald J. Trump and the confirmation by the U.S. Senate. As a first-generation college student and a respected education policy expert with more than 2 decades of experience, Mr. Kent serves as the top federal official for higher education. As Undersecretary, he oversees the department's post-secondary education, career, technical, and adult education, and federal student aid programs. This includes managing the $1.6 trillion federal student loan portfolio and the over $30 billion Pell Grant program. Mr. Kent is responsible for implementing President Trump's mission to restore the greatness of American higher education and ensure that our taxpayer-supported colleges, universities, vocational schools, and other post-secondary programs are genuinely helping high school graduates and working adults launch and grow their careers. He spearheads the implementation of President Trump's landmark legislation, the One Big Beautiful Bill Act, which will lower the cost of higher education, simplify student loan repayment, expand workforce training options, and hold institutions accountable for degrees that do not provide a return on investment. Before joining the U.S. Department of Education, Mr. Kent served as the Deputy Secretary of Education for the Commonwealth of Virginia under Governor Glenn Youngkin. And in that role, he led efforts to reduce the cost of higher education, expand access to career and technical education, and increase institutional transparency and accountability. Mr. Kent previously served as Chief Policy Officer at career education colleges and universities, where he advocated for federal policies and supported career-focused education and promote choice and innovation in higher education. He was also the founding president of CQ's Research Foundation, a nonprofit organization dedicated to advancing data-driven solutions to support student success. He's also served in executive roles at a private sector education company, where he led regulatory and accreditation operations for a national system of post-secondary institutions. And finally, Mr. Kent has experience in K-12 education, having served as the Director of Policy, Planning, and Research at the District of Columbia Office of the State Student Superintendent of Education. He began his career in education policy as a professional staff member at an accrediting agency recognized by the U.S. Department of Education. He holds a bachelor's degree in political science from West Virginia Wesleyan College, go Bobcats, where he attended on a Pell Grant. He also holds a master's degree in higher education administration from the George Washington University. He and his partner reside in Virginia. Mr. Undersecretary, I know that you've hit the ground running and had a busy first week, so thank you for taking the time to be with us. And with that, the floor is yours.
Thank you, Jeff, and good morning, everybody, and welcome to today's public hearing. I'm pleased to be with you all here in my first week as Undersecretary of Education. Shortly after being sworn in this past Monday, I sent my first message to department staff outlining both the challenges and the opportunities currently facing higher education in our great country. In that message, I cited some statistics that should be concerning all to us. One, fewer than half of American adults currently believe higher education is headed in the right direction. Fewer than 1 in 10 college students feel that their speech rights are very secure. Fewer than half of college graduates are actually working in jobs that require a college degree. And 40% of master's degrees have a negative return on investment. Meanwhile, student debt continues to rise, and institutions have gone far too long without being held accountable for their students' outcomes. Today, the federal government holds a nearly $1.6 trillion student loan portfolio, with millions of borrowers either in forbearance, delinquent, or in default on their payments. Simply put, the current approach to paying for college is unsustainable for both borrowers and for taxpayers. To be fair, not all of the blame lies with borrowers or institutions. A significant share of the responsibility rests with the previous administration, which attempted to fundamentally reshape how Americans think about paying for college. Consider its legacy. The Biden administration failed to deliver a timely and functional FAFSA update, burdened families with software glitches and errors, and cost unnecessarily delayed millions of students their financial aid. It told borrowers that they would provide mass student loan forgiveness on 2 separate occasions. After the U.S. Supreme Court rejected their dubious legal theories the first time, they tried it again, refashioning their position to rely on another equally tenuous statute. Courts saw right through the second attempt to use executive fiat to wipe away debt. The Biden administration knew, or should have known, that these actions amounted to a legal Hail Mary. The Biden administration worked very hard to try to keep these actions out of court on standing grounds because they knew they would not win on the merits. Their legal theories were wrong and would have transformed the student loan program into a grant program, something Congress never intended. Borrowers were left in the lurch, falsely believing that there was a real likelihood that their debt would be forgiven. These actions understandably created confusion and frustration for borrowers, many of whom remain uncertain about whether they are enrolled in a lawful repayment plan or how to make qualifying payments towards a legitimate loan discharge programs. Under Secretary McMahon's leadership, the department has been working diligently to restore common sense and integrity to the federal student aid system. Key actions include restarting default collections for all borrowers, resulting in over $200 million already collected, which strengthens the health of our federal student loan portfolio for the benefit of taxpayers and future borrowers. Enhancing identity verification measures to combat fraud, ensuring only eligible students receive federal aid, and supporting institutions in addressing fraud-related challenges. We ended the Clinton-era policy of providing federal aid dollars to illegal aliens and restoring proper and common sense eligibility standards. And we are launching the test version of this year's FAFSA earlier than any previous administration, improving early access and planning for students. This year's application will significantly streamline the contributor process and reduce the amount of time required to verify Social Security numbers, which improves the experience for both students and their families. The time has come to challenge the status quo and restore excellence in American higher education. President Trump has laid out a bold vision, one that aims to disrupt a broken system and return accountability, affordability, and quality to post-secondary education. That includes reducing the cost of higher education, aligning program offerings with employer needs, embracing innovative education models, and holding all institutions accountable when their students' degrees don't pay off. Congress agreed that it's time for major reform. That's why it passed the president's One Big Beautiful Bill Act, a historic piece of legislation that overhauls how the federal government funds higher education and demands a clear return on investment for students, families, and taxpayers. Today's public hearing marks a key milestone in our accelerated timeline to implement this sweeping legislative reform, which was just signed into law 34 days ago. On July 25th, the department announced our intent to establish 2 negotiated rulemaking committees that will take place later this year, to which we intend to submit draft regulations. One will focus on federal student loans. The other will focus on institutional and programmatic eligibility, the Pell Grant program, and other changes to the Title IV regulations under the Higher Education Act. This rulemaking is necessary to implement both the One Big Beautiful Bill Act and other administration priorities. Today, we're inviting you to provide advice and recommendations on the draft Title IV regulations that we will submit for consideration in the negotiated rulemaking process beginning this fall. We want to hear from you on several key questions. What new processes will implement the One Big Beautiful Bill Act? How can we better align federal student aid programs with workforce needs? And how do we ensure accountability for outcomes across all programs at all types of institutions? In addition to the comments we receive at today's public hearing, we are accepting written comments through August 28th via regulations.gov. You may find the link on our 2025 negotiated rulemaking webpage. Thanks to President Trump's leadership, we have a once-in-a-generation opportunity to reimagine higher education by embracing alternatives to the traditional college path, reducing costs, cutting red tape, and holding every institution accountable for results. The time for change is now, and we look forward to your insights today as to how we undertake this very critical regulatory work. Thank you again for being here today. I wish you a productive public hearing, and with that, I'll turn it back over to Jeff to kick us off.
Great. Thank you, Mr. Undersecretary. And that was even under 3 minutes, so bonus points for that. As the Undersecretary noted, the student aid provisions in the One Big Beautiful Bill Act fix a broken system that's built on broken and false promises. But it's time to turn the page on the failed policies of the past and forge ahead to build a better future, one that gives hardworking Americans a chance at a good education that leads to a higher paying job and their shot at the American dream. It's time for a new era for Pell Grants, one with increased focus on helping Americans rapidly gain skills and workforce credentials so that they can be hired for high demand jobs that are aligned with their state's needs. It's time to get borrowers into simple, lawful, and affordable student loan repayment plans where they can pay down their loans rather than trapping them into ill-conceived plans that put them deeper in debt. It's time to implement reasonable student loan limits and to stop making loans for programs that leave students worse off financially than they would be if they've never enrolled at all. And now, finally, it's time to hear from you on how we can make these changes in the President's One Big Beautiful Bill Act even better. And with that, I will turn the floor over to Mr. Jeff Arthur from ECPI University in the great Commonwealth of Virginia. Mr. Arthur, as soon as you're ready.
Okay, thank you. My name is Jeff Arthur, and I serve as Chief Regulatory Officer at ECPI University. I thank you for this opportunity to comment as the department begins implementing the Opportunity and Results Act. I strongly support OBBB's emphasis on program-level accountability, and I urge the department to take this opportunity to enhance and modernize current regulations to align with the statute's intent and the realities faced by today's students. The Higher Education Act clearly requires institutions to disclose a cost of attending the institution, including program-specific costs. Yet the current regulations at 668.43 only requires disclosure of tuition and fees charged and estimates of other costs of attendance. This leaves families without critical program-specific information. To correct this and fairly represent costs of attendance, ED should require institutions to disclose, first, the total amount billed to the prior year's graduates of each program. Also, the median time it took those graduates to complete their program. In addition, the success rate, defined as the percentage of students graduating within 150% of the published program length, and a direct link to the College Scorecard's program level specific post-graduation earnings trajectory data. These disclosures would impose minimal burden on institutions relative to the immense value provided to prospective students and their families. Institutions can easily calculate and provide these metrics, and ED should also consider collecting and integrating this information into the college scorecard, enhancing transparency and informed decision-making. This outcomes data is similar to disclosure requirements from the prior versions of the GE rule. And graduation rates do matter. When you look at post-graduation earnings alone, they can be very misleading. Programs with low graduation rates can appear successful because the few who do complete will usually have strong earnings. Conversely, programs achieving high graduation rates and serving diverse student populations might appear weaker on earnings, despite providing significantly greater public benefit. Success rates provide necessary context to interpret earnings accurately. When you stand those alone, without that context, you just aren't going to get a true
30 seconds remaining.
True measure of a program's value. Current disclosures mislead students. The net price calculator, which was well-intentioned, estimates cost based on the published program length, not the actual time students take to complete. Most bachelor degrees promoted as four-year programs actually experience a median completion time of close to 6 years, leaving students with depleted institutional aid, unforeseen debt in their final years. Clearly, disclosing actual completion time and real total costs would empower students to make better informed decisions with a realistic understanding of the total cost. And I can attest that being subject to gainful employment metrics, it has made our institution stronger and will make other institutions stronger if they are so measured. So thank you for your consideration, and I'll submit more detailed comments.
Thank you, Jeff. Thank you for your comments. Our next witness will be Claire McCann from Post-Secondary Education and Economics Research Center. Ms. McCann, whenever you're ready.
Thank you so much. My name is Claire McCann. I'm the Managing Director of Policy and Operations with the Post-Secondary Education and Economics Research Center. The Peer Center generates actionable research to drive policy improvements in post-secondary education, and we are pleased to provide comments today on the department's forthcoming rulemaking. In particular, I would like to speak to the framework for outcomes-based accountability codified in H.R. 1. Peer believes that the earnings premium test in the law will go a long way toward ensuring adequate returns on the investments of students and taxpayers. We urge the Education Department to also maintain strong gainful employment and financial value transparency requirements in the regulations as an important complement to the new law. As the Peer Center laid out in a recent report available at peer-center.org, only about 1% of students are enrolled in programs that would fall short of the earnings standard. But that figure is much higher for undergraduate certificate programs than for any other credential level, even though the legislation did not apply the same test to those programs. 1 in 5 undergraduate certificate students is enrolled in a program that likely can't clear the bar. A recent publication from the Senate Help Committee's chairman, Bill Cassidy, confirms it was not lawmakers' intent to exempt such programs from any accountability. The publication notes that instead, undergraduate certificate programs would be covered by a similar earnings test under the gainful employment rules. So to carry out that intent, the department should maintain a strong gainful employment program regulation for those programs. That should include maintaining the debt to earnings tests under the gainful employment rules, which are an important check on institutions offering unaffordable degrees. By our count, over $3 billion each year in student loans goes to programs that would pass the earnings test despite loading up their graduates with unaffordable debts. Most of the students affected are undergraduates, and lower graduate loan limits, as under H.R. 1, will not necessarily reduce the total amounts that students borrow as they look to the private market. We also urge the department to maintain the current financial value transparency rules, which will provide unprecedented new information to students, institutions, and policymakers. These data are critical for a well-functioning higher education market, but they may be even more important now
30 seconds.
As the higher education landscape shifts in response to monumental policy reforms under H.R. 1. As the department embarks on this rulemaking, the Peer Center looks forward to continuing to help inform policies that promote an efficient, accountable higher education system with strong outcomes for students. We look forward to sharing additional detail via written comments. Thank you.
Thank you, Ms. McCann. I also want to take at this time the opportunity to introduce Madison Kirvan from the Office of the Undersecretary and my other colleague, Jacob Lalo from the Department's Office of General Counsel, who are also sitting in on this hearing. Our next witness is Ben Cecil from Third Way. Mr. Cecil, whenever you're ready.
Great, thank you so much. Good morning. Thank you for the opportunity to comment today on the Department of Education's upcoming negotiated rulemaking. My name is Ben Cecil. I'm a Senior Education Policy Advisor with Third Way, and we're a national public policy think tank based in Washington, D.C. As the department works to implement recent legislation affecting Title IV programs, sound federal regulations will be essential in ensuring programmatic and institutional quality while promoting transparency and accountability for students and taxpayers' investments in higher education. With statutory changes in the federal student loan program for all students, clear communication that prioritizes borrowers will help with smooth implementation and play a vital role in returning borrowers to effective and timely repayment of student loans. Third Way also encourages the department to allocate adequate time and resources to ensure that federal loan servicers are prepared to effectively answer borrower questions and provide quality guidance. A key task for the department will be the effective implementation of the Workforce Pell Grant program. Third Way strongly urges the department to uphold statutory intent to ensure Workforce Pell has the intended impact. We encourage the department to adopt data-driven definitions for the statutory thresholds of completion, job placement, and value-added earnings that promote consistent accountability while safeguarding student and taxpayer investment against low-quality and high-cost programs. It is incumbent on the department to ensure that those using a Workforce Pell Grant receive a clear, tangible return on investment in the program to prevent waste, fraud, and abuse of taxpayer dollars. Third Way encourages the department to provide guidance for state governors that supports the approval of eligible high-quality programs with strong outcomes while allowing flexibility to exceed federal baselines. Third Way also applauds the congressional commitment to accountability through the new institutional and programmatic accountability measures in H.R. 1. Third Way encourages the department to apply this earnings-based framework consistently and neutrally, ensuring that all programs and fields of study are held to the same standards of measurable value. Third Way also strongly encourages the department to prioritize a full implementation of the Gainful Employment and Financial Value Transparency Framework. The statutory exclusion of certificate-level programs from earnings-based accountability is concerning. As currently written, the GE rule will complement statute to ensure that post-secondary credentials at all levels are required to demonstrate their financial return on investment.
30 seconds.
Finally, a complete and transparent data infrastructure is needed to fully implement the spirit of the statutory language in H.R. 1. As such, the FVT framework serves as a key starting point for understanding institutional behavior and outcomes. The department should prioritize completing FVT data collection this fall and make the data available as soon as possible to ensure the earnings threshold can take effect as the law requires on July 1st, 2026. Thank you for your time and consideration of these comments.
Thank you, Ben. Our next witness is Matthew Hooper from the Council on Social Work Education. Matt, whenever you're ready.
Thank you so much. Well, my name is Matt Hooper. I'm the Vice President of Communications and Membership at the Council on Social Work Education, the national association representing nearly 1,000 accredited social work education programs across the United States. CSWE is here to share our thoughts regarding several proposed policy changes, including the phase-out of Graduate Plus loans, the establishment of new annual and lifetime loan limits, and proposed institutional and programmatic accountability measures. These policy changes will have significant impacts on social work education and broader impacts on the profession's ability to serve students, veterans, and broader communities. First, the complete phasing out of Grad Plus loans threatens to reduce access for students who wish to pursue a degree in social work. Many social work students rely on Graduate Plus loans to complete their master's degrees, secure field placements, and pursue licensure as clinical social workers. Eliminating these loans will negatively impact social workers who provide essential services in every county and parish in the United States, rural and urban. Second, social work should be categorized as a professional degree. Masters of Social Work graduates provide essential services and support for some of the most vulnerable population groups in this country. They pursue careers in healthcare, children and family services, criminal justice, public policy, government, and more. An MSW provides full professional preparation, similar to a JD in law or an MD in medicine, and we think it should be categorized in the same respect. Third, related to institutional and programmatic accountability frameworks and financial value transparency and gainful employment, we encourage the department to recognize social workers for the societal value that they provide to our communities. Social work graduates work in areas that consistently deliver a significant public good, but often at a somewhat lower salary. According to the Bureau of Labor Statistics, at least 30% of social workers are employees in the public sector, where compensation often lags that of the private sector. So, as you already have with the FVT regulations, we encourage the department's accountability frameworks to use longer 6-year cohort periods to measure graduate earnings. And finally, making America healthy means educating more social workers, not less. Social workers deliver the bulk of the mental and behavioral health services in this country. They are the first responders to the opioid crisis. They are among the largest providers of care for both children and the elderly.
30 seconds.
These are returns on investment that formulas and frameworks struggle to recognize. So CSWE urges the department to eliminate barriers to social work education, to recognize the versatility of a social work degree, and to ensure that all students have affordable access to financial aid programs. Thank you so much for allowing us to participate in this hearing and for giving CSWE and our members a voice.
Great. Thank you, Matt. We appreciate that. Our next witness is Jen Zhang from the Student Borrower Protection Center. Jen, whenever you're ready.
Great. Thank you. Good morning, everyone. My name is Jennifer Zhang, and I'm a research associate at the Student Borrower Protection Center. The 2025 Budget Reconciliation Bill will raise the cost of student loan repayment for millions of borrowers, eliminate critical loan programs that families depend upon to pay for college, and expand the Pell Grant to extra short workforce training programs. These changes will strain the wallets of millions of Americans amid a worsening cost of living crisis and our lowest period of job growth since the COVID-19 pandemic. As it considers how to implement the bill's changes, we first strongly urge the department to keep repayment affordable for as many borrowers as possible for as long as possible. The department should maintain all current income contingent repayment or ICR plans until July 1st, 2028. It should not preemptively wind down any plans before that date. Second, the department's failure to defend the SAVE plan, which has made payments affordable for nearly 8 million borrowers, is shameful. The department should preserve the parts of the SAVE final rule that are currently enjoined but were not the subject of the state's SAVE plan litigation. In particular, the department must restore the income-based repayment or IBR option for defaulted borrowers and automatically enroll any borrowers who are 70 days delinquent into IBR. This is especially critical since the Trump administration has resumed forced collections from the paychecks and tax returns of borrowers in default. These collection activities will push millions of Americans below the poverty line over the coming months and force them to choose between paying rent or putting food on the table. Similarly, the department should restore the provisions that allow borrowers to get credit for payments made prior to loan consolidation. Eliminating these provisions is not just cruel and harmful to millions of borrowers, but inconsistent with Congress's mandate. And third, the department must protect students from shady and predatory institutions in expanding Pell Grants to cover short-term workforce training programs. Online program management companies, or OPMs, and short-term boot camps are among many predatory actors that are ready to cash in on this policy. OPMs are private companies that design, market, and teach courses in the shadows, oftentimes under the brand names of traditional colleges. And like the worst for-profit colleges who were shut down in the last decade, OPMs often deceive students with high-pressure sales tactics and inflated promises of job outcomes. Students are then saddled with large amounts of debt, worthless credentials, and broken promises. The department must impose quality controls and assess these programs that are now eligible for Pell Grants so it doesn't open the floodgates to funding
30 seconds.
predatory online degrees. The department has broad discretion in its administration of the student loan system and has the authority to ensure that borrowers are held harmless during this transitional time. We strongly urge the department to adopt these measures to protect borrowers and students from preventable financial struggle and predatory actors. Thank you.
Thank you, Ms. Zhang. Our next witness is Carolyn Fast from the Century Foundation. Carolyn, whenever you're ready.
Thank you. My name is Carolyn Fast, and I'm Director of Higher Education Policy at the Century Foundation, an independent progressive think tank. Students who invest in higher education should, at minimum, end up better than when they started. Yet many programs that participate in federal student aid provide little or no boost to earnings and leave students mired in debt. In addition, Congress has expanded Pell Grant eligibility to very short-term career training programs, raising risks that students will be subjected to a flood of low-value programs, including from for-profit companies eager to exploit this new source of federal dollars. We owe it to students and taxpayers to ensure that their investment in higher education is not wasted. The department can protect their investment by developing robust regulations that set guardrails on short-term Pell programs to weed out shoddy programs, and by implementing the new statutory accountability metric, the Do No Harm test, alongside the gainful employment and financial value transparency rules. The Do No Harm test protects students by excluding programs that do not provide students with the skills to earn more than workers with just a high school diploma from participating in the federal student loan program. However, the Do No Harm test does not protect all students and leaves out the more than 1 million students who use federal loans and grants to attend undergraduate certificate programs every year. In addition, the metric only applies a low-bar earnings test and does not consider whether the program mires students in debt they cannot repay. That is where the gainful employment and financial value transparency rules play a vital role. The GE rule extends the low earning test to undergraduate certificate programs not covered by the Do No Harm test. The GE rule also extends a debt to earnings metric to weed out programs that put students into unmanageable debt. The Century Foundation's research projected that if every student in a program that failed the GE metric instead enrolled in the nearest similar program that passed, their annual earnings would increase by 45%, a boost of nearly $10,000 for the typical student. For programs not subject to the GE rule, the financial value transparency rule ensures that students have access to key information to help them select programs that don't overburden them with debt and provides institutions, the department, and other policymakers with data needed to evaluate how well Title IV programs are serving students. Each of these guard rules plays a critical role in protecting students and taxpayers.
30 seconds.
Thank you for this opportunity to provide comments today.
You snuck up on me on that one, Carolyn. Thank you for your comments. Our next witness is Ewa Obatuashe from New America. Ewa, whenever you have the chance, you can log in.
Good morning. My name is Ewalua Obatuashe, and I am a policy analyst with the higher education team at New America. Thank you for the opportunity to comment today. My comments will focus on protecting students, borrowers, and taxpayers. This rulemaking is a critical opportunity for the department to provide support for borrowers to stay on track with their payments and avoid default. One way to do that is by ensuring that changes to loan limits and repayment options are implemented in a clear and consistent manner. For example, as the department regulates details like how to count payments as borrowers move between plans and what happens when borrowers take out new debt, it should outline clear processes and consequences of different options. Additionally, the department should allow, with borrower permission, delinquent borrowers to be automatically enrolled in IDR plans. Already, the most vulnerable borrowers are the least likely to know about and access income-driven plans. This would simplify and streamline the system for borrowers, servicers, and the department, and help prevent unnecessary defaults. Now, I'd like to discuss programmatic accountability. The new accountability provisions from the One Big Bill are critical to ensuring students and taxpayers get what they are paying for. The department should begin collecting and analyzing data immediately so that initial compliance may be determined by July 1st, 2026, and information on failures may be quickly communicated to students. The department should limit appeals so that the measure remains meaningful. The department should also ensure public transparency of initial passage rates, appeals, and outcomes of those appeals. While these metrics are an important step, they do not include certificates, which have some of the worst earnings outcomes for students and are currently covered under the Gainful Employment Rule. The department has vigorously defended the rule in court, stating it is acute for ensuring the federal government is a good steward of taxpayer funds and for addressing high levels of unpaid debt. The department should maintain GE and FVT regulations, including the debt to earnings measure. These regulations provide valuable information on outcomes for all programs. Finally, workforce Pell programs will require robust guardrails to ensure these programs provide opportunity and value for students and are not a dead end to low-wage, low-quality jobs. The department should ensure workforce Pell programs meet all statutory requirements before a program becomes eligible. The programs are required to be in existence for 1 year, so they should have data to support eligibility. And when programs fail the value-added earnings metric, the department should require a return of funds and reset of student
30 seconds.
to protect students and taxpayers. The department should also ensure public transparency of program approvals, outcomes by program, and dispersal of funds. Thank you.
Thank you, Ella. Our next witness is Sharon DeVivo, president of Vaughn College. Sharon, whenever you're ready.
Good morning. My name is Dr. Sharon DeVivo. I'm the president of Vaughn College of Aeronautics and Technology with an accredited Federal Aviation Administration Part 141 program that prepares students to become professional pilots. Our program serves about 200 students, mostly from low-income backgrounds, who have a dream to become an airline, charter, cargo, or business aviation pilot. As the department considers regulations and guidance following the passage of the One Big Beautiful Bill Act, I want to highlight a growing national challenge with direct implications for education, workforce development, and economic resilience, the worsening pilot shortage. Over the next 15 years, nearly half of our nation's airline pilots will retire due to mandatory age limits. The current training pipeline is not equipped to meet that demand, putting at risk our transportation infrastructure, especially the economic health of small and rural communities to depend on reliable air service. To address this, airlines have raised salaries and developed pathways to careers, but higher education programs, particularly FAA accredited Part 141 institutions like ours, remain essential to solving this challenge. We are where the pipeline begins, and that's why this regulatory ask is so critical. Our students need the financial tools to complete their training and enter the workforce. Training the next generation of pilots is a national economic imperative, but the pathway to becoming a pilot is uniquely costly and complex. Once they graduate from Vaughn with 5 different FAA pilot licenses, they must continue to build flight time to earn their air transport pilot certification, requiring years of additional training after graduation. These are not academic electives, they're federally mandated safety requirements. Because of this, students face additional costs of $80,000 to $100,000. These programs are only offered at the undergraduate level, so students are limited to standard undergraduate loan caps. There is no graduate level flight program to qualify them for higher loan limits like medicine, law, or pharmacy. This is an opportunity for department leadership. The One Big Beautiful Bill Act defines professional students by referencing Section 668.2 of Title 34 of the Code of Federal Regulations. That section defines a professional degree as one requiring a level of skill beyond a bachelor's degree and a professional license to participate. Flight training meets this standard. Our students earn professional licenses, undergo rigorous skill-based instruction, and enter a high-demand, high-paying field. The median salary for a commercial airline pilot now exceeds $226,000. These students are strong candidates to repay their loans and contribute meaningfully to the economy. This is not a request for special treatment. These are undergraduate
30
students.
seconds remaining.
Thank you, that already meet the definition of a professional degree under current regulation. This is a request for alignment between regulatory language, workforce reality, and national need. We urge the department to recognize accredited undergraduate Part 141 flight training programs as professional degrees under Section 668.2. This vital clarification will allow students to access the professional loan limits intended under the Act so they can complete their training, support the aviation workforce, and help keep America connected. Thank you.
Thank you, Sharon. It sounds like I need to sign up for your flight training.
Absolutely, my next life.
Great. Our next witness is Rachel Rivas from Earlham College. Rachel, whenever you're ready. Rachel, you need to unmute.
Sorry about that. I'm Dr. Rachel Revis. I'm an institutional researcher, and I'm talking from that perspective rather than representing my institution. I'm speaking today about the accountability measures. The first thing I want to say is that I urge the department to provide thorough processes, FAQs, and a well-staffed help desk before asking institutions to submit data. We all want to submit the best high-quality data as possible, and we need support in understanding what the department is looking for. My comments today are based on my experiences preparing and submitting the financial value transparency data at a small undergraduate arts and sciences institution, assuming that the new accountability measures may have some similarity to that. A couple of things. So FVT reporting asks for scholarships and grants based on the date of enrollment in a program, which is not necessarily exactly how enrollment works at these institutions. So it seems to assume that students are admitted to the specific program from which they expect to graduate. But at many smaller institutions, students are admitted under a general studies program, which they could graduate from, but they typically then later declare a disciplinary major. And so the date they start that program is whatever date they turned in their paperwork. And so I urge the department to consider these types of institutions. Second, our costs do not vary by program. The tuition is the same for all undergraduate programs. And third, the regulations did not seem to consider what it means for a student to double major. So I ask that the regulations differentiate institution types and program types. For programs that students don't need to be admitted to separately, I ask that the date of enrollment be the date that they started the institution at that level. If an institution has some programs that require separate admissions, they could report those separately. I also ask that regulations recognize that program costs don't differ at some institutions and to allow us to report overall tuition across programs where it doesn't differ. I also ask the regulation writers consider how to handle students who are in multiple programs at once, such as double majors. I also asked the department to consider providing institutions with lists of all Title IV completers rather than just the ones who would be included for calculation purposes. As a very small institution, we had several programs that from our end seemed to just qualify, but we were not getting lists from the department. We guessed it was due to exclusions, but we had no verification and no one responded to our inquiries.
30 seconds remaining.
We also found it challenging that information was submitted through FSA platforms, which in many institutions only financial aid has access to, rather than through a system like IPEDS, where multiple people can be designated for access. Institutional research offices, rather than financial aid offices, have often been responsible for gathering and reporting this information, and having it through the FSA system significantly increased the reporting burden. Thank you so much for this opportunity.
Thank you. Thank you, Dr. Revitz. Our next witness is Jennifer Bell Ellwanger, Data Quality Campaign. Jennifer, whenever you're ready.
Sorry about that. Hi, good morning. Jennifer Bell Ellwanger, President and CEO of the Data Quality Campaign. The Data Quality Campaign is the nation's leading voice on education data policy and use, and we have worked for 2 decades to lift up national best practices and support states as they modernize their statewide longitudinal data systems. Making Pell Grants available to individuals pursuing shorter-term workforce training programs will make it possible for more people to pursue the education and training opportunities needed to reskill, upskill, and further their goals. The Workforce Pell Grant program has great potential to improve the lives of many learners, but it is critical that these efforts are paired with high-quality data and related supports for states as they prepare to oversee and evaluate shorter-term programs within this new context. States will need support to implement the legislation, both technical assistance and capacity support to carry out these long-term programs and address the following 4 issues. First, many states do not currently collect data on short-term programs, particularly non-credit ones, and will need time and support to develop data infrastructure and related practices, as well as coordinate with employers to determine hiring requirements. To address this, ED should support states in leveraging data to accomplish the accountability and reporting requirements needed to make Workforce Pell successful, and consider whether existing funding streams for state post-secondary and labor data systems, such as the statewide longitudinal data system and Workforce Data Quality Initiative grant programs, are adequate to support these efforts. Second, the legislation identifies several metrics for states to use in assessing short-term programs, but these metrics are currently undefined. States will need ED's leadership to create shared definitions, related terminology, and common reporting approaches to ensure the Workforce Pell is implemented in a way that allows for comparability across the nation. ED must also clarify how the proposed guardrails, such as the value-added earnings measure, program completion, and job placement rates, will be appropriately verified by the department and by states. Third, the new Workforce Pell Grant program relies on the use of shared terminology from WIOA and Perkins, including how states define and make use of key concepts, such as in-demand, high-skill, and high-wage occupations. Although some states maintain these definitions as part of their state plans or embed them within other state
30 seconds remaining.
ED will need to provide clarity regarding how these definitions should be used. Fourth, while the legislation discusses the way data will be used to evaluate program eligibility, it is silent on how this information can be used to support individuals. So ED should provide leadership on the development of supports and other tools to help learners navigate their education and workforce pathways. Thank you for your consideration of these concerns and recommendations, and we look forward to working with the Department of Education to make this effort a success.
Thank you, Jen. Our next witness is the distinguished publisher of Republic Report, Attorney David Halpern. David, whenever you're ready.
Thank you. The Trump administration has pursued a well-publicized plan to fight, it says is fighting waste, fraud, and abuse. I hope you know that some of the worst, excuse me, I got a technical problem here. Sorry. I hope you know that some of the worst waste, fraud, and abuse over decades has involved predatory colleges. For-profit schools have received hundreds of billions in taxpayer dollars, yet many have engaged in blatant deceptions and offered high-priced, low-quality programs that leave students worse off than when they started. Part of the problem has been weak regulations that don't include adequate performance standards, and part has been the failure of the department and other agencies to enforce even those weak rules. So far, the Trump administration has made things much worse, weakening your capacity to protect students and taxpayers. You have gutted this department with an announced intent to abolish it, and particularly have weakened oversight and enforcement efforts. Without proper process, you weaken the 90-10 rule in a way that makes it easier for-profit schools to evade that measure of quality. You improperly postponed the next meeting of NASIKI, the advisory panel reviewing accreditors, and improperly deposed the respected NASIKI chair. When Secretary McMahon finally announced in May an initiative to fight waste, fraud, and abuse in student aid, it turned out she was accusing students, not schools, of fraud. And you took an enforcement matter that was done, a well-documented case of blatant deceptive conduct at Grand Canyon University, the largest recipient of federal student aid, and canceled an entirely warranted $37 million fine. The department repeated Grand Canyon's false claim that the enforcement was persecution of a Christian school. Did you note that many of the students victimized by Grand Canyon are themselves Christians? Taxpayers shouldn't fund schools that consistently wreck students' financial futures. You need strong rules to separate good programs from bad ones, and you need to say no when schools and their lawyers and lobbyists try to undermine the rules. Now you need rules
30
for
seconds.
short-term Pell that avoids cynical abuses and bad outcomes. You need a strong gainful employment rule that provides serious performance standards and strong implementation of the new law, cutting off loans to programs that yield low earnings. You should rescind your improper revision of the 90-10 rule, and you need a serious NEGREG committee, including genuine advocates for students. Thank you for listening.
Thank you, David. Our next witness is Valerie Scott, representing herself, student veteran. Valerie, whenever you're ready.
All right, sorry about that. Good morning. My name is Valerie Scott, and I served for 10 years in the Army and the Army National Guard. And I want to share my experience with Argosy University, a school that systematically targeted veterans and military spouses. I attended Argosy for 6 years with the goal of becoming a licensed clinical psychologist. However, Argosy told me lies, and now I am saddled with enormous debt. I signed up for the school after being told that my cost would be around $80,000. Instead, I had to borrow $267,000 to earn my degree. I couldn't even support myself by working while I was enrolled because on the first day of class, Argosy informed us that we were not allowed to work while we were in or have outside employment while we attended the program. Conveniently, they had Grad Plus loan applications on hand for us when they told us this, a type of loan that will soon no longer be available. They had promised veterans that their GI Bills would cover the whole cost and that those without GI Bills would receive substantial discounts, but that could not have been further from the truth. I've spoken with hundreds of other Argosy alumni who were lied to and saddled with loans that they took out to cover the exorbitant cost of attendance. On top of lying about the cost, the school also failed to live up to promises about my education. I was not given the promised supervision by my clinical supervisors. In addition, they were pushing out so many students that there were not enough internship placements available for all of us. But graduating didn't mean an end to the problems that Argosy caused me. When I applied to serve in the Air Force, I was told that they wouldn't consider my application to commission as a psychologist because I attended Argosy University. The school had earned a reputation that impacted the employability of its graduates. Despite making regular payments since 2012, I've watched my student loan balance grow and grow. My debt is now over $400,000. Psychologists do not earn the type of money that would make repaying this type of loan viable, failing any semblance of gainful employment. The salary for people in my field typically ranges from $60,000 to $80,000, a far cry from what we would need to earn to pay off this massive debt. For the majority of Argosy graduates, our only hope of paying off this debt is through public service loan forgiveness and income-driven repayment plan loan forgiveness, programs that are now being threatened with significant cuts.
30 seconds remaining.
Schools like Argosy should not be allowed to exist. I've made it my mission to speak out against schools that make mixed representations in order to enroll students. I continue to advocate to the Department of Education to provide relief to students who are wronged by schools. I'm concerned that cuts to the department will leave students like me without any help, and I encourage you to remember experiences like mine when you consider new regulations. Thank you for your time.
Thank you, Ms. Scott, and thank you for your service. I hope that we can get you into one of our new lawful repayment plans and help you start paying off your debt. Our next witness is Itzhak Kornfeld, representing himself. Whenever you're ready.
Are you able to hear me, sir?
Yes, we are. Go ahead.
Right. Good morning. I took out loans to go to law school in 1987. As you may recall, that was the beginning of the savings and loan crisis, and therefore it was a high interest rate. And then I took, that was to go to law school, and then I took more loans to go for my master's in law at Georgetown. Now, I am 72 years old. I owe $180,000. I have been paying for years and years, and it is not unlike digging a hole to China, because the interest rates keep going, and you can't get out from under them. Now, we renegotiated, my wife and I, twice for our mortgage to lower the amount. But you can't do that with student loan servicers or banks. What you got is what you got, and you keep paying interest. That is not fair. One should be able to renegotiate the interest, or the government should just put in a 3 or 4% interest rate. I'm now paying 8%. Okay, so I'm probably going to die before my loans get paid, and it seems to me, just from a business perspective, that the servicers would lower their interest rate so they could make money rather than me dying on them. And I also think, since the government has the power to do that, that it should set, as I said, I think a 3 or 4% interest rate at the highest should be set. That is my testimony, sir, and I appreciate your time.
And we appreciate your time as well. Thank you. And as you noted, in the prior administration, we had very much a broken system of repayment, and so we're about fixing that now with this new bill.
Thank you very much. Have a lovely day.
You too. Thank you. Our next witness is Martin Pritkin from Purdue Global Law School. Mr. Pritkin, whenever you are ready.
Hi, can you hear me okay?
We sure can.
Great, thank you. Bringing down the high cost of education and promoting innovation are key pillars of the One Big Beautiful Bill Act. The act rolls back certain Biden-era measures that created undesirable incentives. I would submit, however, that the rollback is incomplete. Specifically, 34 CFR 668.14B32, as amended effective July 1st, 2024, targets distance education programs in ways that deprive students of the freedom to choose lower-cost, innovative educational solutions. It provides that an online program designed to lead to licensure cannot enroll students from a state unless the program satisfies the state's licensure requirements upon graduation. While this may have been intended to prevent students from enrolling in programs that won't serve their career goals, in many cases it has the opposite effect, preventing students from making well-informed decisions and pursuing their professional dreams. The institution that I lead, Purdue Global Law School, is the nation's first fully online law school. We make a high-quality legal education available to those who cannot attend a fixed-facility law school due to work or family care commitments, military service, physical limitations, or other reasons. Our tuition is just 1/3 the cost of the average American Bar Association-approved law school. But because we are fully online, we're not eligible to even apply for approval from the ABA. Several states allow our graduates to sit for their bar exams and get licensed upon graduation, notwithstanding our lack of ABA approval, but there are many students in other states who would like to enroll in our program, knowing full well they cannot get licensed in their states upon graduation, but are prevented from doing so by federal regulations. Why would someone want to enroll in our program knowing they can't get licensed in state upon graduation? There are many reasons. Even with an out-of-state license, a lawyer can practice in immigration court in any state in the country. The same goes for federal tax courts nationwide and close to half the federal district courts. And in about half of states, there is a path to getting licensed in state after getting licensed in another state. We are very clear with prospective students about the licensure limitations of our program, yet many still choose Purdue Global anyway because we meet their needs and can help them reach their goals. This is especially true for older, non-traditional students or students in rural or other underserved areas. Our fully online format allows these students to remain in their communities during and after law school, and because they can graduate with far less debt, they can better manage to provide affordable services to modest means clients. But under 34 CFR 668.14 B32 as amended, many of these Americans don't have the option of choosing our program.
30 seconds remaining.
No matter how well informed they are. A repeal of this counterproductive rule would be entirely consistent with the student loan goals of the OBBBA. I thank you for consideration of this comment.
Thank you, Martin. Our next witness is David Bain Boehm from the American Association of Community Colleges. David, good to have you back whenever you're ready.
Good morning. I'm David Boehm, Senior Vice President for Government Relations at the American Association of Community Colleges. We appreciate this opportunity to provide comments. AACC represents the nation's 1,204 community colleges. I'll address five areas this morning. First of all, community colleges feel strongly that we should have their own dedicated seat at the negotiating table. We have consistently been provided for this. We enroll close to 40% of all the students in higher education, and we have different perspectives on some key issues from four-year public institutions that we are merged with in the announcement that was made, particularly in the area of workforce Pell. So we urge the department to reconsider the representation of community colleges as it has been provided so far. Secondly, reporting requirements. There are a variety of data reporting elements to the various programs and the financial value transparency regulations that are on the table in this process. We are excited the department is undertaking this. We think that there is a great need to try to harmonize and simplify these different reporting requirements as much as possibly can be done. We do encourage the department to take a look at the model that was put into place in the financial value transparency gainful employment regulations. We think in general that's a pretty good approach to making sure that the data reflect the program performance. Moving on to gainful employment itself, we do think that the department and ask it to limit gainful employment sanctions, if any, to loan programs only. The recent budget reconciliation bill included a focus or limited the focus only to loan programs. And we think that that same approach, given Congress's approach on this, should be adopted by the department. Fourth item, workforce Pell Grants. Everybody knows how incredibly important this is, how thankful we are to Congress for enacting it with the support of the administration. We are hoping that possibly there could be early implementation of this program, given the fact that a final rule is unlikely to be in place by November 1. We're very interested in how the earnings data that will be used to determine in part program eligibility will be generated, given some of the complexities in the statute. The issue of the 70% completion and placement rate,
30 seconds remaining,
which is also a statutory requirement, is of great interest to us. We assume institutions will have a primary role in that. And finally, the state role, of course, is very key, particularly in terms of evaluating some academic aspects of programs. Finally, in terms of loans, we continue to think that small balance loans should not have a repayment period of 30 years. And then finally, we are extremely interested in the new authority that student financial aid officers will have to reduce loan maximums. We look forward to working with the department on that. Thank you very much for giving me this opportunity this morning, and we look forward to working with you as the process moves on. Thank you.
Thank you, David, for your comments, and we look forward to working with you as well.
Thank you.
Our next witness is Captain Bob Carey from the National Defense Committee. Shoe Bob, when you are ready, the floor is yours.
Unmute.
You are unmuted,
start the video.
You're ready.
Okay, good. Sorry, I'm so informal. I just came from service-connected disability physical therapy. Hey, I'm going to talk about the changes in institutional and program accountability. First off, I'm Bob Carey, retired Navy, and I'm the executive director of the National Defense Committee, a veteran advocacy organization that focuses on military and veteran constitutional, legal, and civil rights. And one of those is freedom to contract. One of those is the ability of people to be able to use their money the way they see best. And the fact of the matter is that military and most military and veteran educational benefits are earned educational benefits. I had to sign on for 6 additional years to be able to get my GI Bill. I had to give something for that, just the same as my retirement. And for someone to say that I can only use my GI Bill benefits, or that my children can only use my GI Bill benefits when I can pass it to them in certain ways, is like saying, here's your military retirement check, but you cannot shop at Safeway to get your groceries. You can only go to the military commissary to get your groceries. And that's fundamentally wrong. The fact of the matter is that the financial transparency, the gainful employment, the 90-10 online program management rules are all essentially arbitrary and discriminatory rules against non-traditional students, especially military and veteran students and their dependents who use their post 9/11 GI Bill. And it seems to me that this process, these rules are much more about protecting traditional public and private nonprofit schools, market dominance, than it is about protecting students. And the fundamental fact is that if you want to, don't use regulations to try to prevent crime. If someone engages in criminal activity such as fraud or deception, prosecute them, turn them over to the state attorney general, sue them, tell me about them, and I'll file a qui tam lawsuit under the False Claims Act, and we'll all make money off of it. Military and veteran students are not dumb. They do not need to be protected from themselves. When I was on active duty, America's parents trusted their sons and daughters' lives to me. But once I become a veteran, and now the American government no longer trusts me to be able to make my own choices, thank you. For-profit schools aren't in and of themselves the problem, and the persistent ideology within this community that the mere presence of for-profit colleges is dangerous is condescending and infantilizing students, especially military and veteran students. No one is holding a gun to anyone's head when they sign up, when they enroll in a school, or when they sign up for a loan. And the fact of the matter is that loans have risk, hence the interest rate on them. And if you don't think that, thank you very much.
Thank you, Bob, and thank you for your service. Our next witness, thank you. Our next witness is Chase Sackett. Chase, whenever you are ready, the floor is yours.
Hello, my name is Chase Sackett. Thank you for the opportunity to speak. I work with some of the nation's leading nonprofit workforce development providers and intermediaries, including sectoral employment programs and employment social enterprises who participate in the America Forward Coalition. My comments address the implementation of Workforce Pell. The organizations I work with are excited by the opportunity Workforce Pell presents to expand high-quality, short-term job training programs with outcomes protections. This opportunity is particularly urgent in light of the long underinvestment in many of the workforce programs that rigorous evidence shows provide the largest impacts on participants' economic outcomes. In addition, many of these organizations have experience partnering with institutions of higher education or are interested in doing so through Workforce Pell. I would like to share 3 recommendations and look forward to sharing more detail in a written comment. First, I recommend prioritizing steps to enable and encourage college workforce provider partnerships. Many promising partnerships between non-institutional providers and colleges are hampered by unclear or restrictive rules around data reporting or program design. I urge the department to unlock innovative, high-quality partnerships by eliminating red tape to the extent possible. For example, I recommend ensuring an orderly process for any accreditor approvals of non-eligible providers' partnership in Workforce Pell programs. Relevant to all programs, I suggest setting clear, specific, timely processes under which governors will determine that programs meet the relevant workforce-aligned criteria for Workforce Pell. And I encourage you to consider including non-institutional workforce providers as a distinct constituency group in the AHEAD committee. Second, I recommend clarifying time requirements for eligibility. The OBBBA requires that programs have been offered for at least 1 year to qualify. However, it also requires assessing programs' value-added earnings 3 years post-exit. The department should take the most straightforward interpretation and allow programs to qualify for Workforce Pell so long as they've been in existence for at least 1 year. And if the program has not been in existence long enough to demonstrate 3 years earnings data, temporarily qualify through shorter-term earnings outcomes. Allowing a temporary, quicker path to eligibility would strike an appropriate balance between valuing programs with demonstrated benefits and the need to support new programs responsive to a rapidly changing labor market. Third, I encourage the department to leverage high-quality administrative data to measure program outcomes. To measure value-added earnings, I encourage you to take the same approach as the Bipartisan Workforce Pell Act. Leverage administrative data from the National Student Loan Data System matched to federal earnings data, such as from the IRS. I also encourage you to leverage administrative data to measure job placement rates to improve accuracy and reduce burden. However, annual IRS data is insufficient for that, as Congress required the department to assess job placement 180 days post-completion. I suggest the department explore other options that provide for quarterly data reporting, such as using states' employment insurance systems. Thank you very much.
Thank you, Chase. Our next witness is Greg Iskowitz. Greg, whenever you are ready. Okay, looks like we don't have Greg there now, so we're going to move on to Heather Perfetti, Council of Regional Accrediting Commissions. Heather, welcome back. Good to see you, and the floor is yours.
Thank you. Good to see you, Jeffrey. My name is Dr. Heather Perfetti, and I currently serve as the president of the Middle States Commission on Higher Education and as chair of the Council of Regional Accrediting Commissions, also known as CRAC. We thank the department for recognizing accreditors as a necessary constituency group to be represented on the AHEAD committee. We also appreciate this opportunity to speak on several areas of the recently passed Budget Reconciliation Act and the regulations necessary for its implementation. This new law will undoubtedly bring many changes to higher education, affecting institutions and students alike. It will create new opportunities for low-income students to take advantage of high-quality, workforce-driven programs. While our institutions have long offered non-credit and continuing education programs, Workforce Pell Grants will certainly expand these and other related offerings. Accreditors stand ready to assist institutions as they navigate both state and secretarial approval of these programs. Accreditors remain positioned to monitor these offerings, their outcomes, and the overall impact on institutional quality through our rigorous review processes. Another significant provision of the law is related to program accountability. We have a strong interest in protecting students in cases where institutions discontinue a program or lose Title IV eligibility. The impact of the implementation of these provisions will be important, as we will need to appropriately consider when a teach-out may be needed for students to minimize disruption in their academic journeys. CRAC does want to reiterate that many of our institutions offer programs for critical fields that are unlikely to meet the high bar for earnings. As a result, the negotiators cannot forget about the possible impact on these students, institutions, and communities. CRAC represents a range of institutions, and these changes have the potential to impact the very core of diverse missions, institutional dedication to service in their communities, as well as financial viability. Here again, accreditors will work with institutions to nurture quality and student-centered programs and services while ensuring compliance with any new federal expectations. Finally, it is important to note that the vast amount of data that will be required to carry out the new law effectively will be important. In many cases, existing data will be available, but new processes and collections will also likely need to be established. New data requirements should not be overly burdensome on institutions, and negotiators should take into account current data collections and accountability provisions such as gainful employment and financial value transparency regulations. CRAC appreciates that the department has added both of these as part of the AHEAD agenda. Again, on behalf of CRAC, we will look forward to working with the department on regulations that can be implemented efficiently without administrative burdens and with clear returns returns on investments for all constituents. Thank you.
Thank you, Heather. We appreciate your participation and your comments. I look forward to working with you as well. Our next witness is Tracy Schneider from Middle States Commission on Higher Education. Tracy, whenever you're ready.
Thank you. My name is Tracy Schneider, and I'm here on behalf of the Middle States Commission on Higher Education. I'm pleased to share these comments with the United States Department of Education for negotiated rulemaking committees to develop proposed regulations. As you are aware, our agency is a voluntary, non-governmental institutional accreditor that has been recognized by the Secretary of Education since 1952. As a member of the regulatory triad, the Commission remains a partner in efforts at strengthening institutional accountability and consumer protection. We currently accredit over 500 institutions. I want to comment on the significant modifications of student loans and student loan repayment programs enacted by recent legislation. As a student-centered accreditor, we support any regulations that ensure efficient processes for all student loans and the allocation of Title IV funds, as well as streamlined pathways for workforce development programs that lead to post-secondary degrees. Our institutions always benefit from clarity in these processes, as do we. As a Title IV gatekeeper, we're required to ensure that these institutions meet all legal and regulatory requirements, and we assist the triad in ensuring that. However, we also advocate for our institutions to meet any requirements without administrative or financial burdens so onerous that they too significantly impact the ability to operate or fail to serve students that all of us are here to protect. Given the anticipated regulatory proposals that will substantially impact financial aid administration in community colleges, it is essential that the negotiated rulemaking committees include meaningful representation by financial aid and community college administrators and professionals. The full extent of the potential changes and the clarity necessary with such changes needs to be fully considered by those who hold expertise in the implementation. I also want to speak to the proposed changes in institutional programmatic accountability measures for programs with low earnings outcomes. We certainly support such measures as we already have accountability mechanisms heavily embedded within our standards and requirements. Like with all initiatives based on data, the success of this demands consistency across the regulatory triad in establishing measures that are valid, reliable, and able to be applied across all types of programs, and in recognition of differences in earnings across geographic areas. Significant consideration must be given to the potential negative impact of limiting certain programs that align with institutional mission and provide value to the community our institutions serve, even if they are not typically high-earning programs. In addition, increased engagement across the regulatory triad will be critical to ensure that all regulators hold an understanding of the status of programs,
30 seconds remaining,
how students will be impacted, and what protections will be in place. With regard to 34 CFR 602, while not the intended topic of this round of negotiated rulemaking, we always want to offer support for continued refinement of the regulations, impacting accreditors in light of the focused review process to gain efficiencies while also addressing the most critical areas of regulation. Our Commission thanks you for your time today and thanks the committee members who will dedicate their expertise and their time to this important process. Thank you.
Thank you, Tracy. Our next witness will be David Canberg from Adams State University. Go Grizzlies. David, whenever you're ready.
Good morning. My name is David Canberg. I'm president of Adams State University, located in a rural, isolated, low-income area of Colorado. I'm presenting public comment, particularly on the ROI portion of the legislation that will be negotiated. I'm concerned because it uses statewide median income of high school graduates relative to college graduates. The statewide measure is not representative of different regions of states. Where I work, the median household income is $47,000. In Colorado, it's closer to 80. So comparing our college graduates, the majority of whom stay in the San Luis Valley, to median high school graduates' incomes statewide, will present significant challenges and won't be a valid measure. Likewise, we tend to graduate students into public service fields. They tend to make less, significantly less than a lot of occupations that only require a high school degree. But these counselors, school teachers, and others have extremely high value to society. So I would ask that the committee and the department think carefully about creating a more valid measure that represents the different regions of states and also the critical occupations that so many of our regional university graduates go into. And please have a negotiator that represents regional universities serving rural low-income areas. Thank you.
Thank you, President Tamberg. Our next witness is Greg Iskowitz. Greg, when you are ready, welcome.
Hello, do you hear me?
We do. Floor is yours, sir.
All right. Hope everyone's having a nice day. Thank you for the opportunity to speak. This is in regards to, I saw one of the bullets was streamlining the IBR repayment plan process. So I am one of the many borrowers caught in a troubling situation regarding eligibility rules for the new income-based repayment plan, or IBR 2014. I consolidated my loans in 2016, and at that time I had no other outstanding loans. Under the law, specifically 34 CFR 685209, a borrower is considered a new borrower if they have no outstanding balance on a direct loan or FFEL program loan on July 1st, 2014, or on the date the borrower obtains a loan after that date. So that's me. And many other borrowers, and I meet that definition in full. And for years, studentaid.gov has showed me as eligible for new IBR, and I accrued 225 qualifying payments towards forgiveness. So my entire repayment strategy and all the choices I've made in life, starting a family, et cetera, have been based around this 20-year timeline that the new IBR offers. But recently, my eligibility was revoked without notice, and I've been told by some that I'll need to be moved to the old IBR with a 25-year forgiveness window and 15% of my paycheck versus 10% what I was paying previously. I've spoken to FSA reps. Some confirmed that I've qualified, some weren't sure. Even a supervisor from FSA verified that I should be eligible, but there's still no clear public guidance. Meanwhile, outside organizations are calling my previous eligibility a system bug, and that's alarming, obviously, because if we're really trying to protect borrowers, how is it fair that the oldest and most responsible borrowers are the ones being asked now to pay more and longer? The oldest borrowers are now being asked to continue paying more than the newest borrowers and longer than the newest borrowers. So if the law is this clear and the system approved for years, how is changing the rules now considered borrower protection? So I urge the department to clarify the regulation policy, honor the forgiveness timelines borrowers have relied on, and ensure that the system works for borrowers and not against them. And that's really all I have to say.
Thank you, Greg. And sorry for the experience you had with the repayment plans in the prior administration, and hopefully we'll get you on the right track and back to repayment. Our next witness is Melissa Byrne, Executive Director and founder of We the 45 Million. Melissa, when you're ready, the floor is yours.
Hi, good afternoon, or good morning, everybody. My name is Melissa. I'm with We the 45 Million and do a lot of work on student loan relief. And right now, I'm just here to say, I really hope that people at the Department of Ed just do nothing right now, because what you're planning on doing will hurt borrowers, will hurt people that the only crime they've committed is not have rich parents. Because unfortunately, in the department that's now led by a billionaire, the purpose is to help protect the children who are wealthy, to make sure when they enter the workforce, they don't have to compete with the children of the poor. That's why they're defunding education. That's why they're making student loans more expensive. And I just really implore everybody who's still remaining as staff at the Department of Education to put borrowers first, put students first. And, I roll when you have Trump operatives telling people that borrowers are the problem, poor people are the problem, because that's not the issue. That's not what vulgarity is in America. Vulgarity is, 14 million people that are going to die because of the USAID cuts. It's people not going to be able to go to college because they're poor. It's folks that are in repayment that are going to go into default. And every decision that you're making right now, it's not because you care about borrowers. It's not because you care about students. It's because you're doing whatever Russ Bolt or weirdos at the Heritage Foundation think, which is the opposite of what Americans need or want or care about. Parents care about their kids having a future. They work so hard for it. And then you're taking away that future. So I just really hope that everybody who's remaining at ed, the people who weren't riffed, which was also an act of vulgarity, aren't harmed anymore. And so honestly, guys, just really do nothing. Just keep the status quo going for the next few years. So people who actually care about democracy, who care about America, who care about students, teachers, parents can come in and clean up the mess that's already been made. You're seeing the highest default rates and delinquencies in the last 20 years. That isn't because of Joe Biden. That's because of the people on the Republican side who did the lawsuits, who wanted to protect Mohila's profits over borrowers' futures. And you guys have choices to make. And I hope that everyone who's at the Department of Ed and the people you pick on the committees, I roll Trump and his administration and put borrowers and put students first and actually care about the folks that are impacted by the decisions that come out of like the people on Mass Ave with Heritage Foundation, because they don't care about us. They care about themselves. They care about whatever corporate job they're going to get in a year or two, or whatever like guy's going to show up with gold to like say thank you for whatever you're doing. Think about borrowers, think about students, think about parents, think about community members, think about the folks who could cure cancer if they're not cut out of the education sector, and all of those things. And just be better, do better, and I roll bad people.
Okay. Thank you, Melissa. Thank you for your comments. I will note that for the record that both the Undersecretary and I are first generation college students and former Pell Grant recipients. Our next witness is Abby Schaeferworth from the National Consumer Law Center.
Hi, thank you. So yes, I'm Abby Schaeferworth. I'm the director of the Student Loan Borrower Assistance Project at the National Consumer Law Center. Our project provides student loan analysis in public education, and we support legal aid attorneys across the country who work with low-income people navigating the student loan system. We also participate in the 2021 through 2023 IDR rulemaking, and we write the leading treatise on student loan law. I'm commenting today to urge the department to use this rulemaking as an opportunity to restore key repayment reforms that have been thrown into uncertainty by the SAFE litigation, and to implement additional reforms to help all borrowers, and low-income borrowers in particular, to successfully manage their loans. First, the department should restore key repayment reforms that were included in the 2023 repayment regulations that make repayment work better. This includes restoring automatic enrollment in IDR for borrowers who fall behind on standard plan payments, automatic annual recertification in IDR, allowing borrowers who are in default to participate in IDR repayment plans, and ensuring that when borrowers consolidate their loans, they get to keep the credit that they've already earned for making qualifying payments already. Additionally, the department should add new protections to ensure that falling behind on repayment doesn't threaten people's ability to meet their basic needs, including by capping collections at no more than what a borrower would owe in an IDR plan. Second, the department should do more to help borrowers get back into good standing through rehabilitation. Changing the limit on the number of times a borrower can rehabilitate is a step in the right direction, but to make rehabilitation truly work, more is needed. The department should make it easier for people to enter rehabilitation agreements by allowing them to apply online, just as they already can for consolidation in IDR. They should make it easier for people to successfully complete rehabilitation by stopping all other involuntary collections once the borrower enters a rehabilitation agreement, so borrowers aren't having to make double payments. And the department should fix the well-known problem of borrowers rehabilitating and then promptly redefaulting by enrolling borrowers who consent in data sharing into IBR or the RAP plan upon successfully completing their rehabilitation, and ensuring effective communications to borrowers about their new repayment obligations. Finally, I want to urge the department to be really careful when amending regulations to limit forbearances and eliminate economic hardship and unemployment deferments. We and other legal aid attorneys work with borrowers who are in economic crisis.
30 seconds remaining.
They've often just lost jobs, they face eviction, utilities cutoffs, and may be living in shelters. For these borrowers, having some way to temporarily postpone payments until their life is stabilized can be an essential lifeline to preventing default and further economic distress. So please keep these folks in mind and think carefully about how to address their needs. Thank you.
Great. Thanks, Abby. Appreciate your comments. At this point, we are going to take a short break until 10:45, and then we will rejoin you all. So get another box of popcorn, and we'll see you back at 10:45. Welcome back for the second half of our morning session in this hearing. We are now joined, in addition to Jacob and I from the department, to Ashley Rich, our new Chief of Staff in the Undersecretary's office. Ashley, welcome. And hopefully everyone is hydrated and caffeinated for the second half of the morning. And so we will jump in to our next set of witnesses. On deck, we have Leah Mezzoso from Adtalem Global Education. Leah, when you are ready, the floor is yours.
Thank you. My name is Leah Mezzoso, and I am commenting on behalf of Adtalem Global Education, the largest healthcare educator in the United States, shaping the future of healthcare by preparing a workforce with high-quality academic programs across 5 Title IV institutions. My comment focuses on changes in institutional and programmatic accountability measures, including the Do No Harm earnings test established in the One Big Beautiful Bill Act, or OBBBA, and the Financial Value Transparency and Gainful Employment Regulation, or FVT/GE. The Do No Harm test requires that the earnings of program graduates must meet or exceed the earnings of a broader population of 25 to 34-year-olds. Within the OBBBA, Congress directed the department to determine the median earnings of each programmatic cohort of graduates, as well as the earnings and population of the comparator groups. We urge the department to carefully craft its rules to ensure an apples-to-apples comparison. Finally, we encourage the department to take this opportunity to streamline other regulations in light of OBBBA. With the introduction of the Do No Harm measure, the 2024 GE accountability rules become either redundant or excessive. To eliminate this issue, the department can simply replace GE's debt to earnings ratio and earnings premium measures with the OBBBA Do No Harm measure and apply it only to undergraduate certificate programs, which are not covered by the OBBBA. With this update,
we call it OB3 if you want, if that's quicker.
Sure, I will take that into consideration for the rest of this. Thank you.
Okay.
With this update, the GE rule should be rescinded for all other programs as accountability is adequately covered by O3B. Is that OB3? OB3. Do no harm measure. We recognize the FVT rule may still have value, and we are generally supportive of the department's efforts to make useful data available to consumers for all programs in all sectors equally. I promise there are no more references. If the department chooses to keep the current GE accountability framework, we strongly suggest simplifying the high hurdle for establishing a qualifying graduate program, or QGP, which enjoys a longer earnings window due to postgraduate training such as residencies or internships. The department should streamline the convoluted criteria for counting a program as a QGP that somehow fails to encompass all programs with periods of postgraduate training, such as the Doctor of Veterinary Medicine programs. Thank you again for this opportunity to speak with you.
I know I interrupted you. If you want to take a few seconds and wrap up, if you have it, feel free.
No, I'm good. Thank you so much.
All right. Thank you. Appreciate your comments. Jacob, I think we need to trademark OB3. So if you guys in OGC could help us out on that one. All right. Solid. Okay. Our next witness is Sabrina Calazans, Executive Director for the Student Debt Crisis Center. Sabrina, when you are ready, the floor is yours.
Thank you. Good morning. My name is Sabrina Calazans. I'm the Executive Director of the Student Debt Crisis Center, an organization representing 2 million folks across the country. I'm here today to express strong opposition to the proposed changes to federal student loan programs, particularly those that would eliminate Graduate Plus loans, impose new annual and lifetime borrowing limits, eliminate ICR and pay, phase out unemployment and economic hardship deferments, and introduce a new repayment plan called WRAP. These proposed changes would cause extreme harm to student loan borrowers and the broader higher education landscape. They would push more individuals toward private student loans, which carry higher interest rates, fewer protections, and less flexibility, and make higher education even less accessible for working and middle-class families. We would see increased loan default rates, which are already surging across the country, and a worsening shortage of critical professionals. Ending Grad Plus loans would be especially damaging, as these loans allow students to finance grad and professional degrees in fields like teaching, law, and medicine. all of which are essential to our communities. So eliminating this option will disproportionately harm students from low-income and underrepresented backgrounds, shutting them out from careers that our society needs. Combined with the new borrowing caps, these changes will force students into private student lending or abandoning their educational goals altogether. Just yesterday, we spoke with individuals who are considering delaying or foregoing graduate programs such as law school or a master's degree due to fears that these proposals will prevent them from covering the cost of attendance and having to take on private student loans. Students are concerned about high costs, but we all need to be even more concerned about what will happen when we don't have enough doctors, teachers, and critical professionals in the coming years. The proposed RAP plan is also troubling with the elimination of $0 monthly payments and stretch repayment terms to 30 years. RAP is effectively turning student debt into a student loan mortgage. It also excludes Parent Plus borrowers and will increase financial stress for countless families. Combined with the proposed elimination of unemployment and economic hardship deferments, these changes would remove the safety nets that borrowers rely on during times of crisis, which leave them vulnerable to default, wage garnishment, and tax refund seizures. Every day, we're hearing from borrowers who cannot afford their current payments or who are currently in the safe forbearance, unsure how they're going to manage their payments when they resume. More than 5 million Americans are currently in default, with millions more at risk of defaulting in the coming months. So removing these affordable repayment options will force people to choose between meeting their basic needs or paying their student loans, a decision that no one should have to make. These proposals will make college less affordable, worsen inequities, and harm millions of Americans. I strongly urge the committee to reject these changes and instead work towards real solutions that make education more affordable and student debt more manageable. Thank you for your time.
Thank you. And I will note for the record that these changes are statutory, now the law of the land, and not optional. So our next witness is Mary Harrell, from the National Association for the Education of Young Children, NAEYC. Mary, the floor is yours.
Thank you. Hello, I'm Mary Harrell, Senior Director for Higher Education at the National Association for the Education of Young Children. Our membership includes approximately 50,000 early childhood educators, faculty members, students, and advocates across the country. And our mission is to increase access to high-quality early childhood education for all children birth through age 8, and to support those working within the early childhood education profession. Early childhood education is a high-skill, high-demand, but low-wage profession, and we are concerned about the potential impact of the low-earning outcome provision on the quality and supply of childcare across this country during a time in which every community is experiencing shortages. The Federal Student Loan Program is an important support for early childhood educators, 80% of whom hold degrees or college credits, who rely on access to early childhood education degrees to be prepared in the core competencies of our profession and to increase opportunities for career and wage advancement. We urge the department to ensure that regulations for the low earning outcome provision do not limit early childhood educators' access to early childhood degrees. And we have 4 primary considerations for the regulations. First, regulations should define program at the broadest level possible to allow for maximum flexibility for students using federal student loans to choose and afford programs aligned to their education and career interests, and to reduce administrative burden for higher education institutions complying with the reporting and tracking requirements related to which programs are eligible for federal student loans. As such, we encourage the department to define program at the 2 or 4-digit zip code. Second, regulations should ensure the accuracy and relevance of the wage data used to set the threshold of wage comparisons for graduates. Census data shows wage differences based on geographic areas within states, occupations, gender, and race and ethnicity. And we're concerned that using aggregated data would unfairly impact students and programs within IHEs located in more rural areas of the state, as well as programs preparing individuals for high skill but low wage professions such as early childhood education, social work, and public education. Third, regulations should exempt programs from preparing individuals for qualifying public services as defined by Congress in the Public Service Loan Forgiveness Program. And these include early childhood education, military service, law enforcement, public education, and public health. PSLF was created to incentivize individuals to work in these professions that are high skill but often low wage. And if the provision is enacted across all degree programs, this could impede students' access to federal student loans that allow them to pursue careers in essential public services. Finally, implementation for this high-stakes provision should be delayed to allow the department and higher ed institutions time to prepare and ensure the accuracy of the data, particularly debt-to-earnings metrics currently being collected, calculated, and publicly reported for the financial value transparency requirements. Lessons learned from this data collection can inform implementation of the low earnings provisions. Thank you for this opportunity to provide this perspective from the early childhood education profession.
Thank you, Mary. Appreciate your comments. Our next witness is Tom Harnish from the State Higher Education Executive Officers Association, better known as SHEO. Let's see if Tom is there yet. Okay, Tom, the floor is yours.
Thank you. Good morning. My name is Tom Harnish. I serve as Vice President for Government Relations at the State Higher Education Executive Officers Association, known as SHEO. Founded in 1954, SHEO is the national association representing state chief executives of statewide governing, policy, and coordinating boards of post-secondary education and their staff. The negotiated rulemaking committees outlined in the July 25th Federal Register notice offer an important opportunity to shape the implementation of the sweeping higher education policy changes included in the One Big Beautiful Bill Act. This law has significant implications for states, state higher education agencies, and the students we serve. We appreciate the department's inclusion of state perspectives on both negotiated rulemaking committees, which follows through on the department's stated commitment to elevating the state role in education and rebalancing the state-federal relationship in higher education. While many provisions in the One Big Beautiful Bill Act will affect states, two stand out as particularly consequential for the SHEO community: the Pell Grant exclusion related to other forms of grant aid and the implementation of the workforce Pell Grants. First, the Pell Grant exclusion provision, which eliminates Pell Grant eligibility when a student's state, institutional, or private grant aid meets or exceeds the cost of attendance, has raised implementation concerns among state higher education leaders and financial aid professionals. Many SHEO agencies administer need-based aid and promise programs that are designed to build upon Pell Grants, using it as a foundational award. We look forward to working with the department and the higher education community to ensure that the implementation of this provision adheres to lawmakers' original intent, minimizes disruptions and administrative complexity to existing state grant programs and financial aid processes, and ensure that students are receiving consistent, clear messages about their eligibility for financial aid. Second, SHEO sees tremendous potential in the workforce Pell provisions to meet state workforce needs. However, effective implementation will require coordinated efforts by both state and federal leaders. Governors will determine program eligibility based on job requirements of in-demand, high-wage occupations, and many SHEO agencies will play a vital role in advising governors, engaging with industry leaders, and overseeing state education and workforce data systems. We welcome the opportunity to work with the department and other members of the committee on defining key terms in the new law and ensuring workforce Pell is effectively integrated into the broader array of state workforce programs. We thank the department for the opportunity to comment and for its continued engagement with state education leaders. We look forward to contributing to these critical discussions in the months ahead.
Thank you, Tom, and we thank you for your comments, and we too look forward to working with you as we proceed. Our next witness is newly minted Dr. Emmanuel Guillory, Senior Director for Government Relations at the American Council on Education. And Emmanuel, congratulations on your recent graduation.
Thank you, Jeff. I appreciate that. Okay, so again, my name is Dr. Emmanuel Guillory. Thank you for having me. As it relates strictly to the implementation of the One Big Beautiful Bill Act, we believe that clear and direct communication is critical for students, borrowers, and families to understand the new annual and aggregate loan limits and the new student loan repayment plans. So the department should ensure that all internal software is updated in a timely fashion to adhere to the changes in the law and provide clear instructions to include relevant resources to financial aid administrators to allow them to properly notify students and families. Also, the department should clarify whether the new loan limits apply to loans that were originated or dispersed on or after July 1st of 2026. The department should create and disseminate a comprehensive list of programs that would be considered professional degree programs. At the very least, the list should include nursing-related programs and programs identified in the Federal Register as meeting the definition of qualifying graduate program in the Financial Value Transparency final regulations, because these programs are identified as needing professional licensure. Proper staffing should be in place to implement the full scope of the One Big Beautiful Bill. With an additional $1 billion in funding for student aid administration, the department should retain a sufficient workforce to ensure a smooth transition for all current students, families, borrowers, and institutions of higher education. The data used to determine the median earnings for each program should be made publicly available in a clear and concise manner to help those students and families better understand the future projections of the programs that they're enrolled in. Further guidance is also needed on the requirement for institutions to package non-federal grant aid before the Pell Grant and on institutional accountability reporting. The Pell Grant is still first dollar, except in the very narrow instance of non-federal grant aid covering the full cost of attendance according to congressional intent. And the One Big Beautiful Bill does not require institutional reporting of data regarding accountability. However, institutions are able to appeal the earnings data if they believed it is needed. So further guidance is needed regarding what data and in what manner institutions should report to appeal the median earnings data from the U.S. Census Bureau. Also, the data should consider processes from the FET regulations and prior gainful employment regulations to determine small programmatic cohorts, the appeals process, in ways that institutions can regain programmatic eligibility. Lastly, the negotiated rulemaking committee should add additional constituency groups to include financial aid administrators.
30 seconds remaining.
Also, a comprehensive seat for HBCUs, TCUs, MSIs, and an additional seat for two-year public institutions of higher education. This would be in addition to four-year public institutions of higher education, private nonprofit institutions of higher education, and private for-profit institutions of higher education. And with that, I conclude my remarks.
Thank you, sir. Appreciate that. Look forward to working with you. Our next witness is Chris Chapman from Access Lex Institute. Give Chris a chance to come into the room and get on. Chris, the floor is yours.
Hey, thank you, Jeff, and thank you to everyone from the department for the opportunity to address you today regarding federal student loan policy. My name is Chris Chapman, and I'm the president and CEO of Access Lex Institute, nonprofit membership organization, which is comprised of almost 200 nonprofit and state-affiliated U.S. law schools. We have a 42-year-old history of helping aspiring lawyers succeed from admission to law school to admission to legal practice. While we'll be offering more extensive written comments, I'm here today to highlight and advocate for two important matters that I hope will be well taken and integrated into the applicable regulations. The first is the need for the department to clarify the definition of professional student that currently exists in the regulations. Specifically, we ask that for purposes of federal student loan limits recently enacted, the definition expressly include LLM degree candidates in joint JD programs, such as JD MBA degrees. The recently passed act, and in fact, the current regulatory framework for federal student loans recognize that students pursuing certain advanced professional degrees, such as law and medicine, have higher costs of education. However, with the changes included in the act, we're concerned that the current definition of the regulations does not clearly extend to those students pursuing LLM degrees or joint degree programs, such as JD MBA or JD MPH programs, despite the rigorous academic and professional demands that they entail. Failing to include these programs in the definition creates a significant hurdle for students whose career trajectories require additional specialized training. For instance, LLM degrees are increasingly necessary for lawyers to specialize in fields like tax or health. Similarly, joint degrees equip lawyers with interdisciplinary skills in business, public health, social work, and others that are urgently needed in today's complex legal landscape. If LLM and joint degree students are not recognized as professional students for loan limit purposes, this would serve to restrict access for those seeking to fill critical gaps in the profession, as the cost of these programs often exceeds the new federal loan limits, leaving students to rely on high-interest private loans, or in some cases, to forgo these valuable credentials entirely. Including such programs in the definition would enhance educational access, bolster the legal profession's adaptability, and ultimately serve the public good. My second point is equally essential. Under current policy, federal lifetime loan limits seem to aggregate all federal student loan borrowing, including loans that have been repaid in full or part for prior graduate or professional study. This approach will work to inadvertently penalize Americans who demonstrate
30 seconds remaining.
Financial responsibility and lifelong learning. Consider the case of a student who completed a public health master's, repaid their loans, and later sought a JD to effect meaningful policy change. If their previous borrowing counts against their lifetime limits, they may find themselves unable to finance their full law degree, even though they've already honored prior commitments. By including amounts in the lifetime limits that have already been repaid, the policy will work to punish ambition, repayment, and career pivots that enrich our workforce and society. Conversely, excluding such amounts would reward responsible repayment and support the development of well-rounded, highly skilled professionals. Thank you for your time and attention and your consideration of my comments.
Thank you, Chris. It's all good stuff. Appreciate the comments. Our next witness is Carlos Zendejas, Vice President of Flight Operations for Horizon Air. I'll give Carlos a chance to get settled in. There he is. Carlos, the floor is yours.
Good morning. My name is Carlos Zendejas, and I serve as the Vice President of Flight Operations for Horizon Air. We serve 55 communities across the Mountain West, California, and of course the Pacific Northwest and Alaska, connecting people and economies through reliable commercial air service. I'm here today because the need to stabilize the pilot training pipeline is real, and the impact of shortages is being felt across the country, especially in small and rural communities that are losing access to the National Air Transportation System. Over the next 15 years, nearly half of our nation's airline pilots will be forced to retire under the federal age regulations. Since the pandemic, more than 250 U.S. airports have seen service reductions from the industry, and some have lost service altogether. This isn't just a transportation issue, it's an economic threat to entire regions. As an airline, we are doing our part both to inspire new recruits, but also to address costs where we can. We raise salaries, launch pilot development and scholarship programs, and we have worked with flight schools and universities across the country, but we cannot solve this alone. The higher education system and the federal financial aid system must be a part of the solution to address the barriers to entry for this critical career for our nation's economy. FAA accredited Part 141 flight training programs are where most commercial pilots begin their journey, but the training to become a pilot is expensive. It can cost an additional $80,000 to $100,000 beyond a standard undergraduate degree. And the students in these programs, which are only offered at the undergraduate level, are currently capped at a standard undergraduate loan limit. That is not enough to get them through the full path to a commercial airline flight deck. The One Big Beautiful Bill Act gives the department the opportunity to help fix this. It defines professional students by referencing Section 668.2 of Title CF4 of the CFR, where a professional degree is defined as one requiring advanced skills beyond a bachelor's degree and a professional license to practice. Flight training meets that test. The students earn a professional license, train under strict federal safety standards, and graduate into a career with a median salary of over $226,000. And like many other fields, the demands for pilots is immediate, measurable, and growing. These are not high-risk borrowers. They're exactly the kind of skilled professionals our economy needs more of. This is not about special treatment or creating a new classification. These undergraduate programs already meet the definition of a professional degree. What is needed is clarity and action. We respectfully urge the department to formally recognize accredited undergraduate Part 141 flight training programs
remaining
as professional degrees, programs under Section 668.2. This clarification will empower more students to complete their training, ease the pressure on the pilot pipeline, and support the long-term health of our national air transportation system. Thank you for your time and for your partnership of building a strong and sustainable aviation workforce.
Okay, and as the air traffic controller say, good copy on that. Carlos, thank you. Our next witness is Michael Swenson. We'll give Michael a chance to get into the room. And okay, Michael, the floor is yours.
All right, can everybody hear me okay?
Yes, we can. Good copy.
Awesome. Good morning. My name is Michael Swenson, and I served in the United States Army for 6.5 years. I was deployed twice to Afghanistan, where I was wounded and earned a Purple Heart. After leaving the military, I enrolled at Full Sail University for music production. When I first talked to Full Sail, they connected me with a recruiter who told me he was a former admiral in the Navy. The recruiter used his military experience and rank to gain my trust. He told me Full Sail paired graduates with employers and provided resources for the job search. Nearly every promise made by that recruiter was a lie. The classes were terrible. Full Sail set unrealistic expectations for students and never taught us what we needed to know. The accelerated classes were not preparing us for the jobs we wanted. My instructors also had questionable credentials for teaching. I withdrew from Full Sail after 2 years. I got an internship through my own connections, and I learned from my coworkers that I actually needed a degree in electrical engineering for my desired career, not the music production degree Full Sail had put me in. They also told me that my school was a waste of money and there were better schools I should go to if I wanted to work in music. Afterwards, I attended a community college that was much better school. The Introduction to Music Theory class taught me more than all 4 of Full Sail's classes on music theory. I'm now attending Arizona State University to finally earn my bachelor's, but it has taken so much more time and money than it should have. Because of Full Sail's deceptive recruiting practices and poor quality of teaching, I had to start college all over again in my 30s. I've earned enough credits for a bachelor's degree, but I still don't have one because my Full Sail credits were not transferable. I feel like Full Sail stole my GI Bill from me. I believe the Department of Education should hold schools accountable when they lie to students and not allow the veterans who are seeking an education to be harmed. My program at Full Sail only had an 11% graduation rate, so I'm not the only one who was harmed. I am concerned that the cuts to the Department of Education will rob it of its ability to help students like me who've been taken advantage of. I'm sharing my experience in the hopes that something like this will not happen to anyone else. And I think there should continue to be help available for people like me. Thank you for your time as you consider new policies.
Thank you, Michael, for your comments, and thank you for your service.
Thank you.
Our next witness is Caitlin Brazil from the institution Per Scholas. Give Caitlin a chance. Okay, Caitlin, see you on. The floor is yours.
Good morning. This is Caitlin Brazil. I'm on.
You are on.
Fantastic. Thank you so much for your time today. My name is Caitlin Brazil, and I'm president at Per Scholas. We appreciate the opportunity to provide testimony about the establishment of program eligibility requirements for the Workforce Pell Grant. Per Scholas is a proven 30-year-old nonprofit workforce development organization. Our mission is to advance economic mobility through full-time, no-cost, rigorous training, guided by employer demand, and in partnership with a network of more than 800 employers across the U.S. More than 30,000 Americans across 19 states have completed our 12 to 15-week training with outstanding program results. 85% of learners graduate, 80% attain jobs. Our training is evidence-based, and Per Scholas graduates have secured roles with wages 3 times higher than their pre-training income, collectively increasing their wages by $2.4 billion since our inception. Under the newly authorized Workforce Pell, organizations like Per Scholas can now meaningfully assist accredited higher education institutions in meeting employer, workforce, and regional demand. We offer an immediate solution for rapidly expanding program offerings, attracting new learner communities, and enabling strong job attainment outcomes. Per Scholas provides up-to-date curriculum aligned with current industry demands, both nationally and regionally, which include high-value credentials. This can enable college partners to quickly launch new programs or enhance existing ones without significant development time or investment. High-performing organizations like Per Scholas can support higher ed in meeting the required program goals, providing a clear demonstration of return on investment and contributing the added infrastructure to measure progress towards program outcomes. The Department of Education can facilitate these partnerships through guidance, responding to higher education institutions' concerns about governance, resource apportionment, and the requirements and opportunities of partnering, including impacts on FAFSA calculations. We strongly encourage the department to consider total instructional hours when determining how funds may be prorated for high-quality short-term programs, and how administrative burden might be minimized.
30 seconds remaining.
Participation. Per Scholas represents one of just a handful of evidence-based models that has consistently delivered on its promise, focusing on non-degree credentials that lead directly to employment. We believe the Department of Ed can maximize the impact of the Workforce Pell Grant by encouraging partnership with successful accelerated training models, creating robust pathways for learners into high-demand careers and driving strong employment outcomes across the nation. Thank you for your time and consideration.
Thank you. And our next witness is Dr. Penny Callaway from Indiana Wesleyan University. Give her a chance to come in. Dr. Callaway, good to see you again, and the floor is yours.
Good afternoon. My name is Dr. Penny Callaway, and I serve as the Executive Director of Government and Strategic Relations for Indiana Wesleyan University, a private, nonprofit, faith-based institution serving about 15,000 learners across Indiana, the nation, and the globe. Thank you for the opportunity to speak today. It's truly an honor to participate in this important process and to offer input as implementation of OB3 moves forward. I want to express sincere appreciation to Secretary McMahon and the Department of Education for their work to streamline and strengthen U.S. higher education, and for the administration's continued commitment to expanding access and affordability. At IWU, we deeply value financial stewardship. We operate ourselves without debt, and the majority of our students graduate with little to no loan burden. That's a story we're very proud to tell. That being said, the proposed changes, particularly the elimination of graduate and plus loans, gainful employment restrictions, and mechanisms tied to earnings, present real concerns for institutions like ours. As a faith-based university, our mission is not only academic. We help students discover their God-given purpose, what we call their life calling. We have an entire department dedicated to that work. For many of our students, that calling is not about maximizing income, but maximizing impact. Our students become teachers in under-resourced communities, nurses in rural hospitals, social workers in foster care, counselors serving trauma survivors. Some pursue ministry or mission work. Many of our female graduates choose to pursue paths of full-time motherhood for a season before entering the workforce. These are noble paths, often sacrificial, always essential. As a first-generation college student, I know this story well because I lived it. I've been a licensed nurse in Indiana for over 30 years, a family nurse practitioner for 20 years, and a professor for 10 years. And for many of those years, I was a full-time stay-at-home mom, my most important job. When loan repayment models or institutional penalties are tied solely to early or average earnings, the system inadvertently devalues these high-impact careers. Over time, access to graduate education in ministry, counseling, social work, and nursing will decline, not because institutions lack the commitment or students lack the passion, but because the structure makes it unsustainable. I request as public law OB3 is implemented, please look for opportunities to protect space in the system for purpose-driven education. That includes further delayed earning metrics, carve-outs for service-based fields, targeted exceptions for faith-based institutions that are part of denominations, and continued access to graduate and plus loans for programs that serve the public good, even when they don't yield the highest salaries. Indiana Wesleyan University wants to be a part of the solution. We stand ready to partner with the Secretary and Administration. Do you want me to finish up?
Feel free to wrap up, Dr. Callaway.
To design thoughtful policies that balance accountability with access and financial responsibility with human impact. Thank you again to Secretary McMahon, Deputy Assistant Secretary Jeffrey Andrade, and the Department of Education for the opportunity to contribute. It's a privilege to engage in the conversation. I welcome further dialogue with anyone here today, warmly and with great hope for the path ahead.
Thank you very much for your comments. Our next witness is Stephanie Giuseppe from the National Association of Independent Colleges and Universities, otherwise known as NICU. Oh, I'm sorry, Faye, I skipped over you. Stephanie, you're on deck. Faye Markey Black from the Regional Airline Association. Pardon me. Faye, you're ready to start.
Okay, thank you. Good morning. I'm Faye Malarkey Black, CEO of the Regional Airline Association. I represent 15 U.S. regional airlines employing more than 71 Americans. Our members flew 121 million passengers last year. Regional airlines partner with major airlines to bring air service to every corner of the country. Most airports don't have enough passengers to fill large mainline aircraft, so 2/3 of our nation relies on regional airlines and smaller aircraft for flights. Unfortunately, a growing pilot shortage has forced airlines to park aircraft and cut these flights, a crisis for smaller communities. Hundreds of airports lost air service and some went dark permanently. Half of today's airports have far less service than they had a decade ago. Worse, within 15 years, half of our workforce will reach their federally mandated retirement age. Wages have climbed and career interest is high, but barriers to entry are higher. The highest of all is the cost of flight training and the inability to finance it. These barriers put pilot careers squarely out of reach for working families. Accredited Part 141 flight training programs, often embedded within university programs, add around $90,000 in additional cost to a 4-year degree. These are not optional extras. They're federally required flight hours, certifications, licenses, and safety benchmarks. Yet, students in these programs are limited to standard undergraduate federal loan caps. They can't access the higher loan limits available to graduate professional students, even though pilot training meets every test of a professional degree. These students earn a professional license, complete skill-intensive training beyond a bachelor's degree, and enter a high-wage field where starting salaries are 6 figures, senior pilots make more than $500,000 a year, and career earnings can reach $10 million. Airline pilots have this high disposable income on day one, with ample discretionary income after loan repayment. Pilots not only connect smaller communities, their high-wage jobs drive a ripple effect for economic growth. The One Big Beautiful Bill Act positions the department to act. The law defines professional students by referencing 34 CFR 6682, defining a professional degree as requiring advanced skill and professional licensure. Flight training already meets this standard. These students need the same access to the same financial tools their peers in law, medicine, and pharmacy already have. To remedy this discrepancy and help resolve the pilot shortage, we urge the department to issue clear guidance recognizing accredited undergraduate Part 141 flight training programs as professional degree programs. This small but powerful change would unlock federal resources for students, advance aviation workforce growth, and support the economic health of smaller communities and our nation overall. Thank you.
Thank you, Faye. Appreciate your comments. Okay, now, Stephanie, you are on deck. And as soon as you come back into the room here, we'll get started. Okay, Stephanie, whenever you're ready.
Okay, once again.
Okay.
I'm ready.
Okay.
Good morning. Thank you for the opportunity to speak today. My name is Stephanie Giesecke, Assistant Vice President for Government Relations at the National Association of Independent Colleges and Universities, or NICU. On behalf of our more than 1,700 private nonprofit colleges and universities nationwide, I want to thank the department for convening this public hearing and for establishing 2 negotiated rulemaking committees to implement the One Big Beautiful Bill Act. This is a moment of significant federal policy transition, and the department has a critical opportunity to design flexible, thoughtful regulatory frameworks that recognize the different types of institutions that make up American higher education and the students we serve. With respect to the RISE Committee and its focus on federal student loan programs, we urge the department to take a broad and inclusive approach to supporting professional graduate degree programs, as reinforced by the existing definition in 34 CFR 668.2. In today's economy, the majority of graduate education is practical and workforce aligned, preparing students for jobs in healthcare, education, counseling, technology, and much more. A definition that is too narrow risks excluding programs that are vitally important to communities and employers nationwide. We further urge transparent processes for the determination of whether specific institutional programs are considered professional, given the newly imposed financing consequences associated with such classifications. Our member presidents are also seeking clarity and certainty around the newly imposed loan limits. The department can play a critical role in establishing guidance that help institutions and borrowers plan with confidence while preserving access to graduate education and supporting upward mobility. We stand ready to support a regulatory approach that is student-centered and workforce-aligned. With regard to the AHEAD Committee for the design and implementation of new accountability metrics, we urge special attention to two principles: accurate data and clear compliance directives. Institutions must be able to rely on the integrity of the data provided and on clear expectations for how to demonstrate and maintain compliance. Particularly for small campuses with limited administrative capacity.
30 seconds remaining.
Transparency and predictability are critical for success. Unintended consequences can and will arise from opaque or overly rigid systems. The data used must be methodologically sound, appropriately contextualized, and matched to the realities of institutional missions and student demographics. NICU is committed to being constructive partners in this process. We support strong federal programs that serve students well and ensure taxpayer investments are safeguarded. We respectfully ask that pieces of mission-driven students are mission-driven, student-focused nonprofit institutions are reflected in the deliberations. Thank you.
Great. Thank you, Stephanie. Look forward to working with you and the team at NICU as we proceed. Our next witness is just coming on deck here. Happens to be my state senator from the 21st District of Maryland, Vice Chair of the Budget and Taxation Committee, former ambassador to Romania, Miss Senator Jim Rosapel. Jim, the floor is yours.
Wow, what a kind introduction. I apologize. I'm in a phone booth in the Logan Airport Admiral Club waiting for a plane that's late. So I appreciate you letting me get on this at a time that works for both of us. Thank you very, very much. And thank you for doing this. In addition to what you mentioned, which is very kind, I'm a former member of the Board of Regents of the University System of Maryland, former member of the Education Subcommittee in the Senate for 10 years, and most important for these purposes is a leading champion of apprenticeship pathways in Maryland. We have workforce shortages. That's why they call this workforce Pell, because people need jobs and employers need skilled workers. And making the Pell system more friendly to skill-based programs is an incredible step forward by the Congress. And I'm testifying because I hope that the department will use this opportunity in your rulemaking to make the rules for workforce Pell apprenticeship friendly. Apprenticeships are a critical way to deal with our skill shortage. In Maryland, we've set the goal. We want 45% of our high school students, when they graduate, to have completed the high school level or registered apprenticeship. But apprenticeships go beyond high school, and they're going to need training post-high school. And that includes at Title IV institutions. And that's why if your rules can be apprenticeship friendly, it would make a huge difference in terms of scaling apprenticeships in areas like healthcare, IT, logistics, accounting, way beyond the traditional ones that we're familiar with in the United States in the construction industry. Other countries have done this. We can do it. The problem is not the economics. The problem is not human nature. The problem is the rules. And that's where the Department of Education has a huge opportunity in the next few months to make the rules for the workforce Pell apprenticeship friendly. The apprenticeship system is going to have to make some changes too to make itself Pell friendly. I also serve on the Board of Apprenticeship for America, and they are testifying or will be testifying. And they're going to be submitting, and I'm going to be submitting as well, some specific recommendations about how you can make these regulations apprenticeship friendly. And really all I want to do is come on and say, I think it's really important. You have partners out in the states who want to do this. The fact that the law says the governor has to play a role in this is terrific. I'm working with our education agency, our labor department, our governor's office right now to make Maryland's apprenticeship system Pell friendly, and we need you to make Pell apprenticeship friendly. Thanks very much.
Thanks, Jim. And even though we're on the different sides of the political divide, appreciate your leadership on apprenticeships. Something we can work together on. So
absolutely, it's very bipartisan in Maryland and nationally.
Thanks again. Safe travels back.
Thank you. Bye-bye.
Okay, our next witness is Donald Franklin from the Veterans Education Project. Donald,
thanks so much.
Looks like you're ready to go, so the floor is yours.
Absolutely, and thank you for the time. As you mentioned, my name is Don Franklin with the Veterans Education Project. I'm the executive director here. The Veterans Education Project is a nonprofit veteran service organization that aims to highlight innovation within higher education and to support veteran and military students and their families. We are committed to nonpartisan research, engagement, and policy implementation for the efforts to protect the benefits and support systems that are necessary for veterans and military students to succeed in their educational pathways. Veterans Education Project, we support the broad regulatory vision laid out in the One Big Beautiful Act, or the Big Beautiful Bill Act here, and we applaud the shift towards an accountability system that's actually grounded in measurable student outcomes. These reforms that focus on whether students are better off economically after completing a program are fair and common sense, and they are going to improve the economic outcomes for these transitioning service members in their veteran student careers. These outcome-based accountabilities incentivizes institutions to support students throughout their education and also hold them responsible for producing real value, not just merely enrolling students or meeting financial thresholds. And while VEP supports the reconciliation bill's move towards these direct measurements, there is concern about the proposed timelines for measuring earnings among graduates, particularly for the master's and professional degree programs. The reason for this concern is that many such programs, especially in healthcare fields that are critical to the veteran population, require postgraduate licensing, certification, or residency periods that will often depress those graduates' earnings, and it can be up to 6 years post-graduation, which can lead, in our opinion, to inaccurate assessments of the program's value. As written, current benchmarks risk penalizing institutions that provide high-quality training for essential veteran-serving professionals and may discourage the continuation of these programs. Given that more than a quarter of veterans experience mental health or substance use challenges, continued access to qualified behavioral and healthcare professionals is essential. We recommend that final regulations extend the earnings measurement windows for master's and professional degree programs if possible, where earnings typically take a little longer to stabilize. We also urge the department to establish waiver mechanisms that can protect access to quality programs serving high-need student populations. Flexibility in these areas will help ensure a regulatory framework
30 seconds
that
for me.
balances accountability with both accessibility and quality. Finally, we want to emphasize the value of the negotiated rulemaking process. Over the years, this process has been a vital forum for incorporating the perspectives and needs of veteran students. We believe that these proposals are grounded in both data and experience and are faithful to the intent of the One Big Beautiful Bill Act, as well as the educational goals this forum serves to achieve. Thank you again for the department and this Congress to build a system that's transparent, outcomes-driven, and supportive of veterans and those who serve. And thank you again for this opportunity.
Thank you, Donald, and thank you for your work on behalf of our nation's veterans. Appreciate that.
Of course. Take care.
Our next witness is Reed Setzer, Director of Government Affairs for Education Trust. Reed, it looks like you're on, and so the floor is yours.
Thank you. Good morning. My name is Reed Setzer, and as mentioned, I'm the Director of Government Affairs at Ed Trust, which is a nonpartisan, nonprofit research and policy organization dedicated to advancing policies and practices to dismantle the racial and economic barriers embedded in the American education system. So part of our work examining federal student loan policy, we've written about how the burden of student loans negatively affects borrowers financially and mentally, with a special focus on Black borrowers. Because of those burdens, Ed Trust is concerned about the increase in monthly payments for millions of borrowers, especially regarding the nearly 8 million borrowers currently enrolled in SAVE once they are forced out of that plan. While there's some aspects of the new repayment system that are helpful to borrowers, many elements will harm borrowers financially by increasing their monthly payments, eliminating $0 monthly payments, and increasing the amount of payments borrowers need to make to qualify for loan cancellation, among other changes. These changes are concerning because they increase the likelihood of borrowers defaulting on their loans, which can be calamitous to a borrower's financial stability. We're already seeing the amount of 90-day past due student loans start to increase. As such, we recommend the department prioritize the needs of borrowers when creating the regulatory framework for the upcoming changes to repayment. As the Department of Loan Servicers begin conducting outreach to borrowers, those communications should include the following information: Legislation was passed in July of 2025 that will phase out most income-driven repayment plans. Borrowers have until July 2028 to choose a new plan, and the details of all new repayment plan options, including new terms, new monthly payment projections, and new repayment timelines. Furthermore, if borrowers do not select a plan, they should be placed into the repayment plan with the lowest monthly payment. The Department of Services should also prominently display the amount of remaining payments for full payment or loan cancellation for each borrower when they are logged into their accounts. Finally, the annual income verification process via the IRS data tool should remain as frictionless as possible for borrowers while also protecting their privacy. Additionally, as the department begins to regulate regarding the new earnings metric, we strongly encourage the department to keep gainful employment and financial value transparency regulations in place. Those regulations are important accountability tools that are different from the new earnings metric in the following ways. GE contains a debt to earnings metric that accounts for high cost programs that leave students with unaffordable debt compared to their earnings. Additionally, for programs that fail, GE protects students' available Pell Grants from going to those programs, not just federal loans as in the new earnings metric. GE applies to certificate programs, whereas the new earnings test does not apply to undergraduate non-degree certificate programs. And the Fair Value Transparency Regulation provides debt to earnings and earnings premium information for GE programs and eligible non-GE programs. Furthermore, just 1 year of collection and publishing without any material sanctions levied against programs or schools led to hundreds of poor-performing high-debt programs being voluntarily terminated. Finally, the department needs to maintain staffing levels that ensure an appropriate amount of capacity to effectively implement these and many other significant policy changes in the months and years to come. Thank you.
Thank you, Reed. Appreciate your comments and look forward as we work to put borrowers into affordable and lawful repayment plans going forward. I appreciate your support. Our next witness is Jordan Wicker, Senior Vice President for Legislative and Regulatory Affairs at the Career Education Colleges and Universities. Jordan, looks like you're on, so the floor is yours. And you're unmuted. Perfect.
Thank you. Hello, my name is Jordan Wicker, and I'm the Senior Vice President for Legislative and Regulatory Affairs at Career Education Colleges and Universities, the national association representing proprietary institutions of higher education. CECU represents over 800 campuses in the United States, equipping students across the country with workforce-aligned knowledge and skills, from allied health and nursing to mechanics, from welding and the trades to culinary, cosmetology, and truck driving, to name a few. Member institutions offer programs ranging from undergraduate certificate to associate, baccalaureate, and advanced degrees. All of our members are accredited, state approved, and U.S. Department of Education approved. Congress and the President enacted sector-neutral accountability and the expansion of Pell Grant eligibility to students enrolled in quality credentials taught between 150 and 600 clock hours at any qualified and accredited institution. Similarly, the new law provides the institutional authority to limit student borrowing by a student cohort. Each of these policies has been a long-term priority of CECU, and we are pleased to see them become law. With sector-neutral accountability comes acknowledgement that quality education comes from a robust education system with diversity in curriculum and delivery to meet the needs of students and employers. This congressional acknowledgement is bolstered by recent studies and evaluations. According to the Georgetown Center for Education and the Workforce analysis of the most recent year of data, 125 proprietary institutions ranked in the top 10% of all post-secondary institutions for 10-year return on investment. And despite making up just 14% of schools conferring predominantly associate's degrees, proprietary institutions make up 21% of colleges that are ranked in the top 10% for 10-year ROI. The updated Carnegie classifications identified proprietary institutions as leading in student access and earnings, with the highest share of opportunity colleges representing programs that provide the greatest economic mobility. And the Lightcast 2025 Talent Shortages and Student Outcomes Report showed that students at 2-year and less than 2-year proprietary institutions had 5 3/4 times higher odds of credential completion and twice the odds of full-time employment after graduation compared to peers at other institutions. Similarly, the USA Today and Statista found that 41% of the top 250 vocational schools were proprietary, based on graduation rates, salaries, debt payoff time, social mobility, and diversity.
30 seconds remain.
It's about time that higher education accountability relies on sector neutral approach. Students at every school deserve institutional accountability for the opportunities its programs provide. CQ will be submitting detailed written comments for the regulations on the new laws, including changes to the federal loan program, workforce Pell, and the accountability measures, as well as considerations for gainful employment and financial value transparency. Thank you.
Thank you, Jordan. Appreciate your comments and look forward to working with you as we implement accountability standards for all programs and all institutions. Our next witness is John Colburn from Apprenticeships for America. John?
Hi, good morning, everyone. Great to be here. I'm Executive Director, as you said, of Apprenticeships for America. We're a trade association representing over 600 apprenticeship practitioners, advocates from across the United States. And my comments this morning are going to address workforce Pell, and specifically, I'd like to speak to or make a comment about the potential for workforce Pell to be used for apprenticeship and recommend that the AHEAD committee include one or more apprenticeship practitioners as a constituency group in its membership. The intent of workforce Pell, as you all know, is to open up access to grants for short-term workforce development programs that prepare learners for careers in high skills, high demand fields. And that this preparation would be aligned with the requirements of employers. The apprenticeship model is really perfectly suited for this intention. Apprentices learn skills on the job and in the classroom that are by definition aligned to an in-demand occupation. And apprenticeships are seen as the gold standard for workforce development for the strong outcomes they deliver. The Department of Labor data shows that 94% of apprentices who complete a registered apprenticeship are retained in employment with an average annual salary of $84,000. As you all probably also know, the president has set a goal to increase the number of apprenticeships in the United States from current levels of about 680,000 to 1 million. And we think Workforce Pell can help unlock the growth in apprenticeships and help meet this goal. But there are going to be a number of implementation challenges that are going to need to be addressed by the rulemaking so that apprentices can benefit. And I'm just going to give a couple of examples. First, as you know, Workforce Pell programs cannot be longer than 15 weeks. Apprenticeships tend to run for a year or longer. And while the actual instruction in the apprenticeship tends to be limited to contact hours that are about equivalent to the guidelines set for Workforce Pell, they will be delivered over a longer period of time. So one consideration we would like to suggest for the rules is that the amount of time in Workforce Pell can be non-continuous. It can be spread out over a longer period of time. We also know that one of the issues that Workforce Pell was designed to do, sorry?
30 seconds remain.
Thank you, yes. We also know that Workforce Pell is designed to land on a job, and apprentices actually start with a job. It's one of the success factors of apprenticeship. And so there will need to be some design considerations around how we treat the outcomes and also for student financial aid formulas. So in conclusion, I just want to say we're very much looking forward to offering some comments, written comments, and want to again encourage that the AHEAD committee should include perspectives from apprenticeship practitioners. Thank you very much.
Great, thanks, John. That now concludes the morning session. We're a little bit early, which is, I think, not going to be a bad thing for anyone at this point. So we will reconvene for the afternoon session at 1 p.m. There are still some slots available in the afternoon. If you know people who would like to testify, we can accommodate those, I believe. So thanks again for everyone's participation this morning, and we will see you all back at 1 p.m. Thank you.